So, Scott, we got a question from the audience. Is it good we haven't heard from the High Court yet?
Well, I mean, it was last Friday. Was it last Friday? They were going on their
I think it's
holiday break.
I think it's good, and I'll tell you why I think it's good. If they just rush into a decision, they're going to be supporting Bev. If they just had an immediate answer, it was going to be in support of Bev, right? Because that was a no-brainer. They didn't have to think about anything. But because they're having to think about this like really hard, they're having to.
Right.
I think they could be discussing a new case law. I think some case law.
Yes, exactly. So they're going to have a very well written, metered decision, because whatever decision they render in this appeal is going to be precedent setting case law.
Yeah. So I think the longer they take, the better it is. I think that we will be setting case law, because when you heard them arguing, even right there at the SJC, there was very little case law to support either side's arguments. There was the only one that I know of off the top of my head that supports the argument that the defense made was based on racism, that they actually be called a jury to ask them about to poll them.
Right. Exactly. This jury's called back in Massachusetts. It's already long been established. It's already precedent setting, where they call back a jury because they think a jury might have been biased, racist,
yeah. So there was
or whatever. But as far as the jury coming back with this convoluted verdict slip, and then jurors after the trial is over saying, "Wait a minute, we were not guilty, 12-0 on counts 1 and 3." That's a different matter. There's never been a jury called back because of an issue with the voting. They've been called back before from possibly the jury being tainted. They find out one of the jurors was racist. They found out one of the jurors was influenced, or there's been multiple reasons why juries have been called back, but never over this convoluted verdict slip where they might have acquitted on certain charges and not the others, and that the judge purposely ignored Judicial Rule 27A, where the judge may poll the jury on multiple charge and entered not guilties, and she decided to ignore that.
Right. See, I think if you listen carefully to the way the judges at the SJC panel question, like, first of all, we got a positive because it was a panel and not just a judge. But when you listen to the way that they question each side during the hearing, you could hear that they were saying, "What's the case law? What's the case law?" So they could clearly see that there wasn't enough case law to support either of their arguments, and that creates the quandary for them. If there was
that's what Karen Reed's lawyer was basically telling the Supreme Judicial Court.
Right.
I have no case law to offer you because we're on virgin ground here. This has never
right. And
happened.
Then even the other side said that as well. So if one side had the case law to support their argument, I think the SJC, this would have been over with. They would have already handed it down. The case law supports that argument, so they win. But we didn't get that. We got both sides saying we couldn't find enough case law to support either of our arguments. And you could tell by the way they were questioning both sides that they were coming to that realization themselves. There wasn't enough case law to cover this particular situation. So I feel positive that it's taking them so long.
I hope so. I mean, I would like to see two things come out of a Supreme Judicial Court decision here. Judicial Rule 27A slightly modified, maybe where it doesn't say the judge must poll the jury on multiple count verdict slips, but the way it's written now, it just says may. And
right,
it's some people that are much more up on the law than me, basically saying may means not that the judge has a choice whether or not. May means the judge is allowed to pull the jury on multiple count slips like that. Like, in other words, may means more like must. But I think the language needs to be more clear, you know?
It depends on how the SJC says it, but may generally means that it's up to the judge to decide. Must means it's not up to the judge. They must do it. So that's the way I read it, but I could be wrong. I'm not a lawyer, so we got questions.
Yeah, I just don't like the way, I don't like the language in 27A. I just don't like it at all.
No, they need to tighten that up or create some case law to support it. So, which is why I think it's going good.